The Constitutional Court is preparing to hear a case that could redefine how consent is treated in sexual offences law. At issue is whether perpetrators can rely on a subjective belief and consent to avoid conviction, even if no consent was given. The High Court has already ruled parts of the Sexual Offences Act unconstitutional, and now the Embrace Project, represented by its co-founder Germanos Manuel, is seeking confirmation at the Apex Court. Leanne, appreciate your time. Now, why did the Embrace Project feel compelled to take this case all the way to the Constitutional Court?
Good evening, Hugo, and good evening to your listeners. The issue that we have, the issue that we brought to the High Court, which resulted in the institution of our challenge to the Sexual Offences Act, was actually as a result of a rape survivor having approached our organization. She bravely is the second applicant in our case. She told our organization about her experience before the criminal justice system, that she was one of a few fortunate rape survivors whose case went before a trial court, and that even though in her case, the magistrate found that there was unlawful sexual penetration without her consent, she could not convict her perpetrator because the state had failed to prove beyond a reasonable doubt that the accused had subjectively intended to rape her. And that flaw was so glaring for me that we actually then proceeded to take this issue to counsel, who's become part of our legal team. And it was from that this constitutional challenge was born.
Now, could you explain how the current law allows perpetrators to claim a belief in consent even when none was actually given?
So, Hugo, as the law currently stands, if we take the sexual offense of rape, for example, a prosecutor has to prove 4 elements beyond a reasonable doubt in order to be able to obtain a guilty verdict. They have to first prove that there was an unlawful act, that there was sexual penetration, that there was no consent from the complainant, and that there was an intent to do all of these things by an accused person. The problem with intent, because it's currently actually the greatest barrier to state prosecutors being able to get their guilty verdicts, is this application of a subjective test, which actually exists throughout criminal law. It's actually quite an important element of a crime in most crimes, actually, where you have to be able to prove that an accused person intended subjectively to do what they did. Otherwise, you would end up potentially convicting persons of things that they didn't necessarily intend to do. So, for example, theft. You have to prove that somebody intended to take something and didn't just accidentally take it and resulted in a theft. In the case of sexual offences, that becomes extremely difficult when you have 2 people in a crime, where it's a complainant versus accused, what they said versus each other. In the case of this subjective test, the bar or the benchmark is very low. All that an accused has to do is show that their version of events could be reasonably possibly true. And in fact, as the law currently stands, it actually encourages perpetrators not to check whether or not consent was given. Because if you didn't outwardly resist, and that's our main argument, is that without outward resistance, it's almost impossible for the state to prove subjective intent on the part of the accused. And what we're trying to change here is to move away from the absence of consent and focusing on the presence of it by requiring that there at least be a positive act of consent and not just rely on this lack of resistance or lack of expression of non-consent.
So how do you do away with the grey areas? Because it would seem that there seems to still be a grey area. I mean, how do you achieve absolute certainty either way?
The achievement, I don't know that you can ever achieve absolute certainty, but we are trying to improve the odds And by doing that, we're asking that an objective test be used as opposed to a subjective test. Just as an objective test is used in the case of culpable homicide, for example, versus murder, there is a different test for negligence, and that is a reasonable person test. And a reasonable person test asks, could a reasonable person in the position of the accused have foreseen that maybe consent wasn't given, in which case it might cause harm? And if they could reasonably foresee that, did they take any steps to prevent that harm from occurring? And if the answer is no, then in the case of a reasonable person, you didn't act as a reasonable person, and therefore you can't be let off the hook. A person in your position, a reasonable person in your position, could have foreseen that consent wasn't given. And that's actually what we're trying to get to.
Now, I want to talk a little bit about the Centre for Applied Legal Studies and some of the arguments they've put forth. And one of them is, in fact, I think it's your argument. We argue that no evidence was put forward by the Centre for Applied Legal Studies to show that conviction rates in coercion-based model are higher than those in a consent-based model. Just amplify that for us, please.
Okay, I think I probably first have to start from the top. So the Constitutional Court tomorrow will be actually considering two applications, one being ours, the Embrace Project, and the second application for confirmation of the High Court judgment and order, which found in our favor. The High Court found that the provisions we had put forward in the Sexual Offences Act were unconstitutional, and the court also accepted our interim remedy while the legislature fixes this defect in legislation, because once you have a declaration of unconstitutionality, that piece or that provision becomes non-operational. And obviously you can't have that where we can't prosecute, for example, rape, because the definition is unconstitutional. So we ask for a particular type of reading in. The Centre for Applied Legal Studies, they put forward a different argument before the High Court. They agreed that the provisions that we had pointed out in the Sexual Offences Act were unconstitutional, but they wanted a completely different relief to the one that we sought. They want consent to be removed as a definitional element in rape and other sexual offences that have consent as part of their definition. And so they are appealing the High Court judgment and order granted in our favor. And what they are proposing is that we move away from the current model, which is a consent-based model when it comes to sexual offences. That is the model that was chosen by South Africa's legislature, and it is a globally and internationally recognized model. And they want us to move instead to a coercion-based model where you remove consent as part of the element of or as part of the definition of sexual offences. Now, a coercion-based model is also internationally recognized, but it's not the model that we have chosen. And why we are opposing their appeal is because we say that to ask a court to tell the legislature to change a model which is internationally accepted when they've chosen it would be a breach of the doctrine of separation of powers between the court and the legislature. And in order to even be able to get to that point, you would have to show that the consent-based model is unconstitutional, and we argue that CALS hasn't done that.
All right, now as we wrap the conversation, so let's go beyond the courtroom. What impact would this case have on how society views consent and accountability in sexual offences?
I think probably the biggest change that would come in with this ruling that we hope to get in our favour is that it would start a different discussion around sexual consent. That for the first time, we as South Africans would actually be discussing what that looks like and what it looks like, or what it would look like to obtain that consent. Because part of what I didn't say earlier is the interim reading in that we asked for and that the High Court has granted is that under Section 56 of the Sexual Offences Act, where defences come up, we have asked that if an accused person puts up a defense of their belief in consent having been given, they must show that they took reasonably objective steps in order to obtain that consent. And that's a game changer, because for the first time, you are requiring positive act. So now the question will be, what do those reasonable steps look like? And what does receipt of that consent, once you have taken those reasonable steps, what do those look like? So it'll just start a completely new conversation in society, which is highly needed given our abysmal GBVF rates.
Now, as we wrap, let's talk about the amount of advocacy that will be required if, obviously, you are successful in this matter, because it's not about, I suppose, getting justice for victims of rape, right? It's also about preventing it altogether, because there's an understanding of consent.
Absolutely. I mean, for us, and I think for everyone, prevention is better than cure. And the idea, well, at least our organization is very big on advocacy. And we've always pushed the idea of deterrence and prevention, because when you are landing up in court, the harm has already been done. We want to get to a point where our GBV rates are low because they're not being perpetrated, not just because our conviction rates in court are now improved and higher. So hand in hand with the change in the law will come major advocacy. And for the first time, perhaps this advocacy will now be propped up by the fact that people will be looking to know what it means to ask for consent and what it means to give consent in order to avoid punishment. Unfortunately, that's the route that we've had to take in order to ensure that this conversation now happens. But it is an extremely important conversation, and it is a springboard for us to have those conversations and to push them and to push the importance of them.
Embrace Project's co-founder Leanne Germanos Manuel speaking to us ahead of the Constitutional Court, which is preparing to hear a case that could redefine how consent is treated in sexual offences law.